All right. So today I will be talking about the Fourth Amendment to the United States Constitution. So the Fourth Amendment states the right of the people to be secure in their persons and houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So when I use the Brown text, it's a direct quote. So this consists of two phrases. The people and their belongings are protected against unreasonable searches and seizures, and it limits on how warrants can be issued. So first, we'll look at some historical background. English common law, such as in Salmon's case in 1603, asserted that a man's home is his castle. This is a common phrase that we still use today, saying that no matter who it is, any man, their home, they should be able to have it be like a castle. They should be able to keep out who they don't want in. William Pitt, who was a member of Parliament in 1763, stated, "The poorest man may in his cottage bid defiance to all the force of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but not the King of England. All his forces dares not cross the threshold of the ruined tenement." So even if it's a falling down old house, it still is the man's castle, and the King of England cannot enter without proper authority. So there were general warrants, which were being abused by allowing very broad searches. And this led to two famous court cases in England that were fought against these general warrants. So first, Wilkes versus Wood in 1763. John Wilkes was a member of Parliament and a pamphleteer. And he was writing pamphlets criticizing the government and the king. And the government didn't like that, so they went and they arrested him and his 49 associates and seized their papers. So this was a very broad warrant. And he sued that, saying that this general broad warrant of seizing him and his associates and their papers was not legal. And he won his case. He got monetary damages against the government because of this overly broad warrant. And also Entick versus Carrington in 1765. There was a 4-hour search of John Entick's house, and they were breaking into desks and boxes and such looking for papers, and they seized his papers. And this led to a suit that this general warrant, based only on the suspicion that Entick wrote anonymous attacks against the government, was illegal. They didn't actually have proof or know for sure, but they just said, we suspect him, so we're going to search his house. And they did, and he sued them for it and won his case as well, and also won monetary damages because of a overly broad search. In America, there were writs of assistance, which allowed customs officials to search any place for smuggled goods, even without suspicion. So if it was a place where smuggled goods could be hidden, they could search, even if they had no suspicion that there were actually smuggled goods there. So that pretty much allowed them to search most any place. In Paxton's case in 1761, James Otis argued against these writs of assistance, that they were unreasonably broad and allowed searches almost anywhere. He lost the case, but John Adams, who observed this case, called this a spark for the American Revolution. As a result of these cases, the Fourth Amendment was written to curb the abuses of general warrants and writs of assistance. And it recognizes a person's right to private property and to securely hold that property. And the Ten Commandments in Exodus 20, verse 15, it says, "You shall not steal." And 2 verses later, "You shall not covet your neighbor's house. You shall not covet your neighbor's wife, or his male or female servant, his ox or donkey, or anything that belongs to your neighbor." So the Ten Commandments, of course, applies to all of us. You shall not steal. But it's also applied to the government and to the king. The king shall not steal your property, and the government, shall not steal your property, without taking appropriate legal measures. It has to follow the proper procedures, and the Fourth Amendment is part of what sets up those procedures. So before the 20th century, the Fourth Amendment had little effect because, first of all, the federal government had very few law enforcement resources before the 20th century. And modern police forces hired by the government to investigate crime didn't really develop until the middle of the 19th century, mid-1800s. And there were uncertain remedies for violations. So because of these three things that were very limited, there were really very few to no cases that brought up the Fourth Amendment. I mean, it was important to prohibit overly broad searches, but that wasn't really much of a problem because of how we had set up our government. In Weeks versus the United States in 1914, they introduced the exclusionary rule, which states that if you conduct a search which violates the Fourth Amendment, any evidence you gathered in that search cannot be introduced into the court case. So if you broke into someone's house and found evidence that they were guilty of a crime, you couldn't use that evidence in a trial against them to prove that crime. So that introduced an actual remedy that could be readily applied to the Fourth Amendment violation. Now in the 20th century, all three of these reasons are reversed, and there are many Fourth Amendment cases. So the Supreme Court, first of all, incorporated the Fourth Amendment by means of the 14th to make it apply to state and local law enforcement as well. So initially, the Bill of Rights, it's in the US Constitution, so it's a limit on the federal government. But over time, through various court cases, the Supreme Court has said the 14th Amendment, the Due Process Clause, allows the Bill of Rights to also be applied to the state and local governments. So the Supreme Court decided that the Fourth Amendment should also apply to state and local law enforcement as well. So that definitely broadens the effect of the amendment. And also now, instead of very few police, there are 100,000 federal officials with the power to arrest and over 750,000 state and local police. So there's many police, thousands, close to 1 million officials that have the power to arrest. So there's many people that potentially could violate this. And then because of the exclusionary rule can throw out evidence, and there's also civil remedies for violations, there are many cases on the Fourth Amendment. A person might try to claim the exclusionary rule if some evidence was gathered in a way that violated the Fourth Amendment, so that would be thrown out and not used against them. Search and seizure. Seizure is the government taking an item or detaining a person. So it can be taking property away or forcing a person out of their home or taking a letter out of its course of delivery. They take a letter out of the post office to see if it has evidence. That would be a seizure. Person can also be seized when placed under arrest or temporarily detained. For example, when your policeman pulls you over when you're driving, and you're temporarily detained because you don't feel that you have the opportunity to just leave anytime you feel like it until the policeman says, okay, you're done, you may go. So even if you're not under arrest, you could be temporarily detained. So those would count as seizures. And for search, the courts come up with two tests. The first one is a trespass onto a person, his house, papers, or effects to obtain information. So this could be obtaining information from your papers, letters you might have. It could also be obtaining conversations that you're having, information from conversations you're having, such as through a wiretap or a microphone placed to record conversations. And two, a violation of a person's subjective expectation of privacy that society determines to be reasonable. So society, there are certain things that society deems to be reasonable expectations of privacy. And generally an invasion of a person's private space, their home, their car, their letters, their pockets, is something where our society says, yeah, it's reasonably reasonable for a person to expect privacy in those things, but not surveillance in a public place. If you do something in your home, you expect it to remain a private thing. But if you do something in public, it's not reasonable to expect that that's private. You're expecting that somebody could see you, so that it's not a private space. So there's a difference between being in your home and being out on a street if you do something or say something, or that people could see you there. Next, after search and seizure, the question is it reasonable or unreasonable? So a person can be arrested based on probable cause that a crime was committed by that person. If a policeman sees you, speeding and then stops you, he has probable cause that you were going faster than the speed limit and that you were the person that did that crime. So based on probable cause, you can be arrested. And once arrested, you can be searched without a warrant. Basically, that's a part of being arrested, that they can search you without a warrant. A house, however, can only be searched with a warrant unless there are certain exigent circumstances, such as evidence being likely to be moved or destroyed. So if the time it takes for the police to go and get a warrant and come back, if in that time the evidence would have been moved or destroyed, then that's an exigent circumstance, so they could be able to search without a warrant. Or if a suspect is going to flee, they could if the time it takes to get a warrant would allow a person to flee, they could arrest a person before they have the warrant. So there are certain circumstances that, warrant's not supposed to just be a roadblock entirely to gathering evidence or arresting people, or if consent is given. So if the police knock on your door, knock, knock, and say, can we come in and search your house? If you say, yes, you may come in, then you've given consent, and they don't need a warrant. They can just come in and search if you give consent. If police are searching a place and the warrant says they're looking for a particular thing, if they see other incriminating evidence in plain view, they can also seize that. So if you've been accused of stealing Bob's TV of a certain model, and the police get a warrant and are searching for that model of TV, and they come into your house and they see 10 other TVs also in there, they can seize those as being incriminating evidence that maybe you indeed are a TV thief. A driver can be pulled over and arrested for any traffic violation. Even if it's a minor violation, doesn't have to require jail time for the violation. Even a minor violation, you can be pulled over. And if you're pulled over and arrested, then the driver can be searched. The car can also be searched without a warrant if there's probable cause it contains evidence. So for example, if you're driving drunk and the policeman arrests you and he smells alcohol and you're obviously drunk, he could search your car to see if there's open alcohol in the car. So if there is probable cause for having evidence in the car, they could also search that. The exclusionary rule now has many exceptions to it, one of which is the good faith exception. So if an officer is searching your house and is in good faith trying to follow the Fourth Amendment and not trying to break it intentionally, if he thinks he's following the rules, but actually technically he broke some rule, then according to the good faith exemption, the evidence that they find could still be used in a trial. And officers also have qualified immunity. So again, if a reasonable person believes that they are properly following the law of the Fourth Amendment, even if they've technically broken it, they have immunity against being sued. So that's qualified immunity to protect police officers from being sued for violating someone's Fourth Amendment rights. The warrant clause said no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the conditions for a warrant, first is probable cause. So this means more likely than not. It's not an exact definition, but more likely than not, 51%, something like that. It's a lower bar than is given to a jury to convict a person, which is beyond a reasonable doubt. So when you're gathering evidence, you don't know if a person's guilty or not. So you cast a little broader net to gather evidence, but to convict a person, the jury has to be convinced beyond a reasonable doubt. So that's a higher bar to meet. But this is not just, well, there's a slight chance there could be evidence. No, this is probable cause. It has to be reasonably likely. Also, the evidence that's given to support the warrant has to be given truthfully. So the police officer has to swear an oath that they are giving true information. And only specifically listed places can be searched, and specifically listed people or things can be seized. So it's not a warrant to say, we're going to go and keep looking until we find something against you. No, they have to know ahead of time, what you're accused of. This is the particular item we're looking for in this particular place. And it's not a general rummage through your life until they find something against you. And although it's not in the text, early court cases held that and we've continued with that it needs to be issued by a magistrate, a judge. So not the prosecutor's office or anyone else in the executive branch. So if the police are investigating you, they can't say to their buddy, oh yeah, also police officer, oh yeah, I think this guy, did this, and I think that's likely. So would you authorize a warrant? If they're all on the same team, that's not very independent. So they have to convince an independent judge in the judiciary, a different branch of government, that there is probable cause and that the warrant should be issued. So these are a number of things that limit warrants and make sure that they're done properly and not trampling on people's rights. Now, one question that's not answered here is, are warrants required? It doesn't say that they're required. So there are some instances where maybe a warrant isn't needed. At the time, it was kind of a protection for the people that were doing the searching, as we saw in the Entic case, in the Wilkes case, that the people that executed the warrant, the search, were sued because it was not properly issued warrant. So the warrant, if it's properly issued and they followed these rules, provides protection for those executing the search against being sued. So some issues that have arisen from various Fourth Amendment cases are, can non-physical things be seized, like conversations through wiretapping? And the government has, in different cases, has said, like if you're in a neighboring apartment and just out in the room listening and you can overhear a conversation from the neighboring apartment, maybe that's allowed. But if you put a microphone into the wall to hear someone's conversation through the wall, then that's a search because you're actively trying to hear their conversation. So then you would need a warrant for something like that, or to tap their phone to record what they're saying on their phone. Are there limits on what can be observed inside a house from a public street? After all, you're on a public street. If you can observe it, is that allowed? And the courts have said in some circumstances not. One case, the police were using infrared cameras to look for powerful lights that were growing marijuana illegally inside a house. And so it could observe the heat through the wall. They were on a public street, but the court ruled that you expect privacy inside your house. So even if something technically can be observed from outside, there are limits on what the police can observe from outside, so that they couldn't use the infrared camera to look inside your house to see if you had illegal marijuana growing lights. In what instances are warrantless searches allowed? There are some. I said, if evidence is being moved or destroyed, or somebody's going to flee, but also cases such as a building inspector or a fire inspector looking for building or fire code violations. The courts have ruled that it's a lot less scary to have the building inspector inspect your office building to see if things are up to code than to have the police rummaging through looking for evidence of a crime. So building inspectors and fire inspectors can use administrative searches and without a warrant. Or like mine safety, the courts ruled that the government has an interest in keeping mines safe, and if they got a warrant and you had advance notice, maybe you'd clean things up and make sure things were okay. But in general, they weren't. So that a surprise inspection was needed to make sure that a mine was safe. So there are cases where they allow warrantless searches. Is illegal drug testing allowed without probable cause, random drug testing? And there was a case saying that for railroad workers, because the industry was heavily regulated by the federal government, that employees within that industry also had a lower expectation of privacy, and they did allow for random drug testing. So there's a lot of questions in cases where things are not necessarily clear. Are there limits to what can be observed in public spaces? Earlier I said, well, if you do something in your house, that's private, but if it's out in public, it can be observed. But even there, the court has ruled that, like in one case, the police had attached a GPS to a person's car and observed everywhere the car went over the course of a month. And they ruled that that was not allowable, because even though you can be observed in public, watching your every move for a whole month is too much intrusion into your private business. So there are limits on what can be observed even in public spaces. So in conclusion, the Fourth Amendment places limits on government searches of people and their property, must be specific and limited, and search warrants must be supported by evidence giving a probable cause and issued by a magistrate. So it has to be independently, you have to convince an independent magistrate to issue it. It also limits the government's ability to search until it finds a crime. So they have to have a specific crime in mind first that they're articulating and giving as a reason for looking for particular evidence. And it protects a person and their private property from arbitrary government intrusion, from arbitrarily listening to your conversations or taking your private property away. And it says a person has a right to expect privacy, even sometimes in public spaces, like the GPS tracking your car everywhere you go. So as we see from this and previous amendments, private property was very important to the Founding Fathers, and this was one aspect of their protecting of private property.